Hello everyone, welcome back to day 13 of Polity Daily Drill. The time is 8:30. Let's begin our discussion. First question. Consider the following motions: calling attention motion, privilege motion, censure motion, and adjournment motion. How many of these motions can be introduced in either house of the parliament? Of course, we know motions like adjournment motion and censure motion can be introduced only in the Lok Sabha, whereas other motions like calling attention motion or a privilege motion can be introduced in either house, Lok Sabha, as well as the Rajya Sabha. So, right answer is B, only two, that is 1 and 2, not 3 or 4. Second question. With reference to the sessions of the parliament, consider the following statements. Adjournment terminates the session of the parliament. Number 2. The power of adjournment and adjournment sine die or sine die lies with the presiding officer of the house. Number 3. Prorogation terminates the sitting of the house for a specified time. And number 4. Dissolution is applicable in the case of Lok Sabha only. Now, if you look at these statements, the first one, adjournment. What is adjournment? Adjournment means the termination, the end of not session, but sitting of the house. So, one is wrong. Number 2, the power of adjournment and adjournment sine die lies with the presiding officer. Absolutely correct. Adjournment basically means the sitting for the day is over and the house will meet after a particular specified or fixed time, whereas sine die means the date of next meeting is not fixed, and usually the last sitting of any session is adjourned sine die because the presiding officer has no idea when the house will meet next for the next session, right? So 2 is correct. Number 3, prorogation terminates the sitting. See, 1 and 3 have been interchanged. Prorogation terminates the session of the parliament, whereas adjournment terminates the sitting. Okay. So prorogation means ending the session of the house, and just to remind you, this is done officially by the president. Summoning means beginning a session. Prorogue is to end the session. Both these things are done officially by the Indian president. Fourth one is absolutely correct. Why? 3 is wrong and 4 is correct. Why is 4 correct? Because dissolution takes place only for Lok Sabha. Rajya Sabha is not subject to dissolution. It is what we know as a continuing chamber, right? So Rajya Sabha as a house is never dissolved, it continues. The members might keep on changing, and even the members do not change all at one go. 1/3 members retire every 2 years. So 2 and 4 are correct. How many statements are correct? B, only 2. Moving on to question number 3. Consider the following statements regarding the Attorney General of India. He is the highest law officer in the country and is appointed by the President on the recommendation of a 3-member committee comprising of PM, the Leader of Opposition LOP, Lok Sabha, and the Chief Justice of India. Attorney General is mentioned under Article 76. The article is important. I would request all of you to read the article on your own as well. You would find that, yes, he is the highest law officer, we know that, but the appointment which is done by the President is not on the recommendation of any committee. It is simply on the recommendation of the Council of Ministers headed by the Prime Minister, the usual way things are done. So 1 is wrong. Second one. One of the qualifications for being appointed as the Attorney General is that the person must have been a judge of a high court for at least 5 years, or an advocate of a high court for 10 years, or an eminent jurist in the opinion of the President. This is actually correct. Why? These are nothing but the qualifications to be a Supreme Court judge, and that is what is the exact qualification to be an Attorney General as well. somebody who is qualified to be a Supreme Court judge is not a judge, should just be qualified to be a Supreme Court judge. So if you are qualified to be a Supreme Court judge, then you also meet the eligibility criteria to be appointed as an Attorney General of India. So 2 is correct, 1 is wrong, B, 2 only is the right answer. Fourth question. Third schedule of the Indian Constitution provides for forms of oaths or affirmations for whom among the following? The Union Ministers, President of India, Judges of Supreme Court, Governors of States. So third schedule of our Constitution provides for the oath for ministers, ministers of the states, ministers at the central level who take two different oaths, oath of office and oath of secrecy. Then we have the legislators who take the oath. Every person who becomes a legislator at the central level or the state level, elected, nominated, they all take the oath. Then all those people who want to contest elections, candidates, they take an oath. It is mentioned here. Then the oath for the judges of the superior courts like the Supreme Court and the High Courts. And finally, CAG. These people's oath is mentioned in the third schedule, nobody else. So 1 and 3. Right answer is C. When it comes to the President of India, his oath is mentioned separately in an article called Article 60. The same goes for governors. Their oath is mentioned under Article 159. And also the Vice President of India, whose oath is also mentioned in a separate article, Article 69. Right? So C is the right answer. And the last question for today. Consider the following. Assertion reason based question. Capital punishment passed by a trial court cannot be executed without the concurrence of the Supreme Court. Now, if you read the statement here, capital punishment passed by a trial court, meaning a lower court, a district court, cannot be executed without the concurrence of is correct. Not Supreme Court, but the High Court's concurrence is required. So assertion is wrong. Assertion, which is a fact, is wrong. So if you now look at the question, both A and R are correct, not possible. Both A and R are correct, not possible. A is correct, no. D is the right answer. A is incorrect. Now R has to be correct. Let's see. India has a pyramidal integrated judicial structure that provides for control of the High Court over the subordinate ones. This is absolutely true. We know very well that the High Court does control the lower courts. So R as a statement is correct, A as a statement is incorrect. In fact, usually in the examination for assertion reason based questions in the past, you'll always find that either A is factually wrong or R is factually wrong. And in most cases, the answer is going to be either C or D. Anyway, so in this question today, the answer was D. This brings us to an end of our discussion for today. Let's meet tomorrow. Till then, that is all for me. Jai Hind.